So soon?
Yes.
To speak something about. Hello, mic check.
Hello, hello. Hello. Where is this link? Where is this live link?
This is the, that's it, no? MHRDS
Yes.
Innovation Cell.
Okay. On Facebook, should I do that?
Yeah. Okay, great.
I can't seem to find the link. Yeah, it's here, it's here. Got it.
Is it live?
Yeah.
Now?
Yeah, yeah. Good afternoon, everybody. I am Divya Srinivasan from the Cell for IPR Promotion and Management, which is a professional body under DIPP, Ministry of Commerce and Industry. We are here today in association with IIC Mhrd Innovation Cell to talk about intellectual property rights and its importance in the younger generation today. We have here with us Ms. Shwetashri Majumdar. She's an IP expert and she's with CPAM. She's an expert with CPAM. And she will be talking about intellectual property rights and maybe answer a couple of questions that you may want to pose in the comment section for this live video. So please pose your questions to us and Ms. Shwetashri will be happy to answer them for you. So CPAM was formulated in the year 2016 when the National Intellectual Property Policy came out, and we are a professional body to ensure that all the objectives of the National IPR policy are put in place and we move forward for them. So one of the major objectives under this policy is awareness, IPR awareness in schools, colleges and industry associations. And as part of that objective, today we are here to talk about why intellectual property is important and what and the general introduction to IPRs. So I'm now going to hand over the session to Ms. Shwetashri, and she can move forward and with the presentation and later on answer all your questions.
Thank you so much, Divya. I'm Shwetashri and I hope we're over the glitches. So what you see is actually, you can see and hear me and you're not going to be treated to a 2-hour session of mine. So that's the flip side of having two virtual classroom. One, I don't get real-time feedback, and I think the advantage for you is that I won't even know if I've put all of you to sleep. So here's hoping I can successfully keep you awake for the next 2 hours or so, a little short of 2 hours, and tell you a little bit about what I do for a living, what I have been doing for a living for the last nearly 2 decades now, intellectual property rights. I will begin anecdotally with what it's been like to be an IP lawyer. You know how every time you walk into a family setting, a party or a cultural event, and everyone finds out that you're a lawyer, and before you've even bit into your paneer tikka, they want to come rushing at you with issues about property disputes that they have or some contract that they want you to advise them on really quickly. And they sort of begin conversations by asking me if I'm a civil lawyer. I say no. If I'm a criminal lawyer, I say no. And then they say, are you a matrimonial lawyer? And I'm like, no. And then finally, the only fourth form of law that everyone knows about is corporate law. And when I say no to that as well, everyone wonders what sort of a lawyer I am and if I am a lawyer at all. And then when I tell them that I'm an intellectual property lawyer, the usual response I always get is intellectual property law. That doesn't exist in India, right? Because everyone copies everything. So I will begin by telling you that that is probably myth number 101 in intellectual property laws, because believe it or not, our country actually has one of the strongest intellectual property law regimes in the world. So why is there such a lot of misconception about IP? The reason is twofold, and I think I'm told by the folks in the government who are putting all of this together that most of you are engineering colleges and folks with a technical background. So you will appreciate that if you come up with something really innovative and really creative, and if you are not going to let the world know that you have created it, you can hardly complain if someone copies it, because you're actually never going to know that no one else is ever going to know that it was yours in the first place. So what you therefore need to do, which is incredibly important, is protect your IP at the first stage. So before we start talking about everyone's favorite topic, and that is copying, we have to first understand that intellectual property laws as a whole, as a regime, rest on two very strong pillars. The first is the pillar of protection, and the second is the pillar of what we as lawyers call enforcement, and that is ensuring that no one else copies. So we will begin with protection. Unless you understand the nature of what is protectable in the intellectual property law regime, what you could potentially be the rights owner for, you're not going to be able to actually secure rights for yourself. So we are going to begin my presentation with telling you a little bit about what intellectual property itself is. Now, being students of engineering colleges, naturally, all of you have heard about patents to some extent or the other. So the interesting thing about IP is, and here again, I'm going to do a little bit of myth busting, and that is IP isn't something, or intellectual property isn't something that is registered alone, or not something that you have protection for alone, right? The moment you've created something which is the result of your own intellect, that is IP. So it could be anything. It could be a symbol that you use for your business. It could be sometimes, if you're a famous person, it could be your name itself. Sound, music, inventions, all of the things that are up there on the slide, all of them constitute intellectual property. As far as IP is concerned, because we want to have a disciplined protection regime globally, so for most parts, IP rights are considered to be territorial. Now, what are the various forms of IP? They're classified into the following broad heads: patents, copyrights, trademarks, designs, geographical indications, integrated circuits and semiconductor layout designs, plant varieties, and trade secrets. So I'm going to spend the next hour or so telling you a little bit about each of these forms of IP and how you can secure protection for them and what happens when someone violates them. So let's begin with patents. What is a patent? So patent, when you're an inventor of something, now first and foremost, you do need to understand that one of the biggest distinctions we draw in the IP space is the distinction between discovering something and inventing something. I'm sure as science students, I don't need to underscore that distinction for you. But it's not enough for you to be the first person to discover something. For example, if someone is a geologist and they discover a particular fossil, or an archaeologist discovers archaeological remains under the earth, they will be credited with that find, but they cannot say that that find belongs to them alone. So similarly in science, if someone discovers something for the first time, they just happen to chance upon it, that doesn't mean that they have the right over that. What you do have the right over, however, is if you invent something. In other words, you create something that had no existence in the world until you came about and created it. That is an invention. Naturally, therefore, if you create something like that, if you invent something, then you have the right, and that's only fair, right, in the legal regime, that you have the right to be able to prevent others from manufacturing, using, selling, or importing the invention without your permission. So what we have in the patents regime is what we call a quid pro quo system. In other words, we all want science to progress, right? So if everyone held their patents very close to their hearts and didn't share them with anyone, then there would be no progress. We wouldn't have innovations, there would be no technology. I wouldn't be on a Facebook Live session with you. None of this would happen if those who invented things just held them close to themselves. Therefore, the patent system works on a quid pro quo, which essentially means that you disclose what you invented. That disclosure is put there in a patent application. It is filed, and in exchange for that disclosure, what you get is the right to exploit that disclosure entirely for yourself, and in whatever means you think fit. So in other words, others will have the benefit of that disclosure, and you get, as you can see from the bottom of my slide, you get a 20-year monopoly over that invention. So after 20 years, it becomes free for everyone to use. Now, many of you have heard about product patents and process patents. India used to have what was primarily a process patent regime. Now, where that comes in relevant is really in relation to pharmaceutical products, because processes to make pharmaceutical products or things in the field of biochemistry or agrochemical products, those are the kind of products where you can get a protection for the process. Otherwise, overall, whatever product you're creating is what you get a patent protection for. So there are three things that, so the question is, a lot of times people come and they ask me, I have an invention, can I get a patent for it or not? So the idea today is to equip you to be able to answer that question yourself. How can you answer that question yourself? By understanding the three heads that are necessary, the three heads that we as lawyers apply to scientific inventions to understand if they are patentable or not. So the invention needs to be new, non-obvious to a person skilled in the relevant field, and it should have industrial application. So what do these three concepts mean? I'm going to spend a little time on each of them. So we're saying it's a new product or process, that is the novelty requirement. The second is it should involve an inventive step. And the third is that it should be capable of industrial application. So what is novelty? Novelty is something that is new and original, that has never been seen or done before. In other words, if you look at the existing knowledge in that particular domain, whatever that domain may be, it may be technology, it may be, biochemistry, whatever it may be, you look at the existing knowledge in that particular domain and you come up with something which is a technical advancement over that existing knowledge. You do need to, so the existing knowledge is what we call prior art in patents. So you need to look at the prior art and you need to describe in your patent application what is it that you have invented which is different from the prior art. Why is it better than what existed in the prior art? How are you making the process of arriving at the same result more efficient? How are you coming up? So for example, in the field of medicine, sometimes it may be that two particular medicines have to be combined to achieve one result, and you come up with a new salt that achieves the same result better. Or you come up with something that is an absolutely innovative product which cures a particular innovative medicine that cures a particular illness for which there was no direct cure available earlier. So whatever it may be, you will have to distinguish it from the existing available material and say why what you've done is special. And it should not be anticipated by publication in any document anywhere in the world or used in the country. So we're talking about two things here. One is that it should not be published anywhere. So a lot of times the confusion that people have is they think that all they need to concern themselves with is whether there is a similar product in the market. That's not true. Similar product in the market will only satisfy the use test. That is, the product is not in use in the country. But equally, you also need to ensure that the product has not been published in any document anywhere in the world. So in other words, if there is scientific literature where it's been talked about, if there is somebody who has written about it pursuant to a research paper in a PhD thesis, maybe no one's picked it up, maybe no one's commercialized it, but it's sitting somewhere in a PhD thesis that has been published, or there's an article in a scientific journal where someone's talked about it, that will also fall under this particular head. And if that has happened, then unfortunately, that particular invention cannot be granted a patent because it has been disclosed. So what is very, very important is if you believe that you have something inventive that you have with you, you have to keep it a secret. So secrecy is a very, very important part before you apply for a patent application. Now, let's understand novelty with a really simple example. Now, this example is not necessarily something that will get a patent. It most certainly won't. But it's important for you to understand how novelty as a concept is seen. Novelty as a concept, so like I said, suppose there's a disclosure in a scientific paper or something. How do you map that disclosure against what you've invented? So you can turn around and say, oh, but the disclosure says X. Now, X is in the same family as my invention, but X is not exactly my invention. That is exactly what we're talking about. In the novelty test, all that the novelty test concerns itself with is not whether it's in the same family of inventions, but whether what you've come up with is exactly mapped by something which is in writing or in the public domain or in the market. So in other words, if your invention, for example, is describing something that is connected to the wall with the nail, and the publication describes the very same system, but it says that there is a screw instead of a nail, or it has like a double-sided tape instead of a nail, then as far as your invention is concerned, it is novel with respect to that publication. So the fact that that publication talks about being able to connect something to the wall is not enough, because it does not talk about connecting that something with the wall using a nail. And it is this using a nail which then becomes the innovative part of your invention, and that satisfies the novelty threshold. Moving on to inventive step. So inventive step is very simple. It's not about what I as a lawyer consider innovative. It's not about what your parents consider innovative. It's about what your peers and seniors in your particular field of work consider innovative. So the question, the test that is applied is that whatever you've come up with should not be obvious to a person who is skilled in your specific field. Why is that important? Now, for example, let's look at, again, chemistry as an example. Suppose there is a particular medicine which uses the salt of, which uses sodium as a salt. And you come up with something which involves potassium, but is essentially the same thing. So everyone's going to turn around in your particular space and say, what was the big deal about substituting potassium with sodium? Everybody knows that they're both bases and they have similar properties, so you could potentially substitute one for the other. The very fact that there is no medicine in the market which has that similar substitution is not important. What is important is the fact that the two are substitutable for each other is knowledge that was available to a person who's skilled in that particular field. So that substitutability that you have done in what you call your invention is something that your peer or someone else working in that same field should not have come up with as well. Or it should not have been so obvious that people skipped it. Therefore, the test of technical advancement. It has to technically be an advancement, not just an advancement. So something to me as a lawyer may look like incredibly, interesting and innovative and different, simply because I'm not a person who is in the field. I only, as a lawyer, interpret patent documents, right? But to someone who's a scientist, they will look at it and say, this is not an advancement. This, I could have figured out. I mean, this is very elementary. It's a very elementary substitution that we do in the lab all the time. So unless it is a technical advancement compared to the existing knowledge, or is something that has economic significance. Now let's talk about economic significance. Like I said, maybe to treat a particular illness, you were earlier taking a cocktail of medicines. You were taking 3 to 4 to 5 to 10 medicines in order to treat this one particular illness. However, now someone comes up with just one tablet that ends up achieving the same result. That has an economic significance. Why does it have an economic significance? A, because patients are now no longer going to have to buy 10 different medicines. They can perform the same function, they can achieve the same results with just one medicine. So that's a good positive result that you've achieved. There's an economic significance associated with it. And the second is that it could also be a situation where it was extremely inconvenient for someone to have to take 8, 10 different pills every day, which they are now resolving just by taking one pill. So that there is a certain efficiency associated with that process, and that could itself also be an inventive step. Now, example, if you replace a wooden knob in an almirah with a metallic knob, that is not considered inventive. Now, let's mesh what we learned about novelty earlier with what I'm telling you about inventive step. Now, I said that in the prior art, if it talks about fixing something on the wall with a screw, then that would not defeat the novelty of an invention where you talked about fixing something with a nail. However, it would not satisfy the inventive step test, because if you see here, replacement of a wooden knob in an almirah with a metallic knob, that is essentially doing the same thing. Now that may not, maybe the metallic knob is novel because no one thought of a metallic knob before you did. However, it's not sufficiently inventive because someone else who is skilled in that particular space will turn around and say, what is the big deal about this substitution, right? So the question is that, so the question really is that who is a person skilled in the art? A person skilled in the art belongs to that particular field, looks at all the prior art from a position of his or her personality, considering his or her interest in that particular subject, is well aware of the fact that even a small structural change in a product or in procedure can result in dramatic functional changes. That is a person who's skilled in the art, and that person's test is what we apply. Now let's look at the third test, which is industrial application. This simply means that whatever you are coming up with has to have the ability to be used or made industrially. Now, industrial here, you must understand, does not mean that something which involves, for example, the use of handloom is not going to be permitted. The question is not industry as in the sense of a factory or an industry, but it should be something that is capable of large-scale reproduction, something that is capable of being replicated and sold as a product in the market, right? So even if it's new, even if it's non-obvious, even if it has an inventive step, but you can't reproduce it. Whatever you came up with, there's just that one prototype, and for some reason, you can't make it into a commercially viable product. That would not satisfy the industrial application test. Or if you have something that has no practical application. So for example, if you come up with a product or a process which operates in a manner contrary to laws of nature, then that is not something that is going to be patentable. So my favorite example is always the ghost catcher. You often have paranormal activities if you watch late night television, as I do, since I don't get home in the evening to watch television. So late night television invariably means you see a lot of these crime serials and paranormal serials and things like that. So one of the things you'll find is they have all these contraptions and devices with which they claim to catch ghosts. Now that is not something that's capable of industrial application. It goes contrary to the laws of nature. So something like that cannot be patentable. Now I have a question here from the GVP College of Engineering in Visakhapatnam, where someone says, can I get a patent for combining two or more ideas which could result in a new product? Absolutely. The question is not really about whether there is just one idea or two ideas or three ideas. That's not the test. The test is ultimately from the perspective of what results. So the product that you've got, it may have multiple ideas, that doesn't matter. The product that you've got, is it novel? Have you simply performed the function of literally someone who puts together a database? In other words, have you just taken an idea from X, an idea from Y, and an idea from Z, and you've just compiled them together and you're calling it an invention? That is not an invention. So the question really is not about the number of different ideas that go into it. You do appreciate the fact that most products in common everyday usage that we have, let's take the mobile phone, for example. There are literally millions of patents for something as simple as a mobile phone device alone, because there are so many different components to it. From the SIM card, from the fact that there is a dual SIM, to the camera, the front camera, the back camera, the pixel strength, the pictures, the screen, the glass, the fact that it's you've got the full 360 vision or whatever it is. So all of these things are all separate patents. and someone else could have a patent for a bunch of different things put together. So the test is really not about whether it's one singular idea or multiple ideas. The test is whether it's novel, whether it's inventive, and whether it has industrial application. Moving on now to what is not patentable. What is not patentable is something that is frivolous or against established natural laws. We've talked a little bit about this in the context of industrial application. Something that is harmful to human and animal health. So, if you're going to say that this is a particular invention that is going to help in genetic selection, or something that is going to help disclose an invention which, when a woman is pregnant, it's something that will help reveal the gender of the child, and therefore that may end up promoting feticide. Something like that would be contrary to human and animal health. So that would not be patentable. Scientific principles or formulations, mathematical formulae, algorithms, laws of nature, none of these are patentable, right? And discovery of new properties of substances that are already known. So if there is a substance that is already known, so, from time to time, there are all these little myths that float around saying, oh my God, the US has gone and patented turmeric. No, they haven't. We can all breathe. So the fact of the matter remains that when there is a new property of a substance that is already known in nature, you would not be able to get a patent for that particular property. Substances obtained by merely combining two already known substances, method of agriculture or horticulture, or rule or method of performing a mental act or playing games. So something, again, that does not have industrial application, something that you cannot see in a tangible, concrete form is something that you cannot patent. I now have a question from the Samita School of Engineering in Chennai, who wants to know whether software can be patented. The truth is, that itself is a subject worth talking for 2 hours on, for the simple reason that it's both yes and no. Yes, that it can be patented in several countries of the world. No, that it cannot be patented by itself in India. Why is that so? In India, our law, so you have to understand that quite apart from the basic principles of patentability, etc., which I talk to you right now, there are also these criteria that are considered by the Patent Office, which are based on principles that are laid down, which are found to be relevant or whatever. Our legislators in their wisdom laid down certain principles as to what would be considered patentable under the Indian statute. So, for example, an atomic energy related invention or a defense related invention is not patentable. And that's an India specific provision. It may be there in some other countries, but these are provisions that have been introduced in our law. Why? Because there is a security ramification to it. So, defense inventions, atomic energy, specifically not defense per se, but atomic energy inventions are not patentable. So software, interestingly, as far as Indian law is concerned, software by itself, or software per se, as we say, is not patentable. If the software can be shown to have a technical effect, or if the software that you seek to patent is sought to be patented in conjunction with hardware. So if there is a hardware component to it, if there is, for example, a device on which that software is viewable, or that software has a physical, tangible component to it, then it is patentable in India. But our software patents are fairly limited in terms of what is granted. Do we have any other questions on the patent space? See, this is my effort to try and make this as interactive as possible with just a white screen in front of me. So Mr. Raghuraman Rajendran says, how can I find out if my idea already exists in the world? Now that is where you do need to hire a patent lawyer, because what you will have to do is, and this is kind of where my world and your world intersects, because while you will be able to describe your invention and the scientific ramifications of it best, you're probably not going to be able to go through the patent literature that exists and sort of understand from reading prior granted patent documents as to whether your idea is covered in that. So it is a slightly complex field, that is patent searching. So patent lawyers who are qualified to do that go through all these prior documents. It's all there in the public domain. Some of them are through paid sites, some of them are not through paid sites. You could look at Google, for example. Google does have a lot of patent documents that are available free, viewable, so you can start familiarizing yourself with what patent documents look like. So proper subject matter searches are carried out, which are quite complex in themselves, to understand if that idea exists. So in other words, when you're applying for a patent, the first step is actually going to be to run that search and to understand if your idea is available or not. Why is a patent term for 20 years? I know, I wish it was longer. But the idea is that, yeah, that's a question that just came in. The idea is that 20 years is long enough for you to have a monopoly. Ultimately, at some point in time, that invention should be surrendered so that the world can take benefit without having to pay you royalty. So it's balancing public interest versus your, you know, sort of, what should I say, public interest versus rewarding you for the invention that you came up with. So you get a reward for 20 years, that's good enough. In any event, as we know, in most fields, 20 years is long enough for an invention to really become obsolete unless it's a medicinal product. How do you evaluate the commercial value of a patent? That's another question that comes in. Now, commercial values of patents is not something that you can evaluate at the first instance. Now, interestingly, there is something called the Patent Cooperation Treaty. And under the Patent Cooperation Treaty, when you apply for a patent under the treaty, it gives you 30 months. And in some countries, India, for example, has a time period of 31 months, where you decide which countries you're going to extend that particular patent to. Because like I said at the beginning, if you remember the first slide, all IP is territorial. So you can't get a global patent. You'll have to apply in every country. And it gives you about 30 months to decide, once you've sort of filed the basic application, to decide which are the countries where you're likely to have a commercial market for that particular invention. So that's really a mix of, it's very little to do with the law, but it's a mix of what the market needs at that point in time versus whoever is willing to put money, who's willing to, you know, sort of maybe a venture capitalist or, you know, an investor in your company. So people go and make a lot of presentations and things to VCs and you know, folks in the market to see if there is someone who's willing to back that invention. So that really is a lot to do with demand and supply in the market in terms of whether the time for what you invented has come or not, whether the market is ready for it, whether the market actually wants a product like that. And unfortunately, sometimes the greatest inventions don't see the light of day simply because no one's willing to commercially back it. And sometimes, as you've seen in the case of a lot of startups, the simplest idea becomes, you know, $1 billion ideas simply because, you know, the market wants it. So that really is not something that we as lawyers or you as scientists can potentially determine. That's really a lot to do with the market. So we have a question from Bharatidasan University in Trichy saying, if I explore an unexplored region of this planet and find a new living organism or another non-living thing, like a new chemical compound and substance that is endemic there, can I get a patent? I wish this was a classroom because I would have put this question back at you. I would hope that by now I have already answered this question for you, where I've said that anything that exists in nature is a discovery and not an invention. So no, the answer is no. So if you're planning that trip to Mars, don't bring back live material or non-living things from there in the hope that you'll get a patent. Because even if Richard Branson lets you carry it back, you're not going to be able to get a patent for it. Can a method of performing yoga be patented? Oh no, that's not an invention. You didn't come up with it, I promise you. Is it possible to patent a system made using open source components, hardware and software? This is a question from Saraswati College of Engineering. Certainly, it just depends really on what the terms of license of that particular open source components involve. Because if they allow you to claim ownership or commercialize a product made on that particular platform, then certainly you can ask for a patent. Whereas certain open source licenses, so you have to read the license terms really carefully, say that if you create something on this particular platform, you will also have to make it available free of use, only with an attribution, and you can't commercialize it or hold it exclusively. So it really depends on the terms of the platform or license. How does an assignment work in a patent? The Dronacharya Group Institute in Greater Noida, you're getting ahead, aren't you? you've already started thinking about how to commercialize your patent. That's a good way to think. We're going to stop with that, which is going to be the last question, because I do need to work through other segments of my presentation as well. So as far as assignments in patents is concerned, really, it's up to you. So like I said, I did introduce that a little bit in my last answer, where I said that, it really depends on who puts the money on the table. And whoever is showing you the money is going to tell you how they want it, whether they want to own it, whether you want to retain it, whether they are investing in your company, or whether they're buying it from you. To a large extent, if you've got a great patent, to a large extent, it's about how well you negotiate. So having the right lawyers to negotiate on your behalf, or if you're just a born negotiator, then good for you, do it yourself. But there are no rules, really. Assignments and how the rights are given away in a patent and commercialization really depends on how the negotiation turns out at the end of the day. So it really depends. You can say as the inventor that I don't want to assign it. I always want to remain the owner of the patent. And, you can basically commercialize it, but I will be identified as the owner and you'll continue to pay me royalty. That works. And our last question is a patent valid in all countries or only in India? Yes, can I see some imaginary hands there? Like I said, it's territorial. So if you filed under the Patent Cooperation Treaty, you could extend protection to multiple countries, but at the end of the day, you would have to file in each of those countries individually. So yes, patents, like all other forms of IP, are territorial. This is a message which I will be reinforcing in the course of my further slides as well. These are some examples of patented inventions we use every day, things that we don't really give much credit to. I'm sure those of you who have idli for breakfast every single day have never thought about the fact that that idli maker could actually be a patented product. Or the really harmless looking clothes peg with which we hang our clothes outside to dry in the sun. Something that, our little middle class Indian homes, we've all grown up seeing. Those clothes pegs are actually patented inventions. In fact, believe it or not, the Kellogg's cornflakes, the shredded wheat flakes or the Kellogg's cornflakes, all of them are patented inventions. As also the ink with which, the indelible ink that is put on our fingers when we cast our vote, that is also a patented invention. So that is something that, that is the reason why you can't really come home and wipe it off and then go back and cast your vote again for whichever party you support. So that is because it's a patented invention which makes it partially indelible for some time at least, or at least until the elections are over. So that is a patented invention as well. I'm told that you were listening to me in a dark room for a bit. Do we have, we got the feedback? Okay, brilliant. So now we're going to move on to the next segment, which is copyrights and related rights. We're moving away from patents, but not away as far as you're concerned from science, because you'll be surprised at how much overlap there is between patents and copyrights. So now copyrights are exclusive rights that are given in law for literary works, dramatic works, musical works, artistic works, cinematograph films, and sound recordings. Secret revelation. I've spent like the last, nearly 2 decades trying to pronounce cinematograph films. I haven't got it right yet. Someday I'll get it right. So as far as copyrights are concerned, now copyrights are very interesting because many people ask me this question that, what a strange name. Does that mean that you have a right to copy? It's very interesting, right, how the word came about. So if you look at the origin of the word, it really is a right not to copy. And copyright, unlike patents or other forms of IP, is the only form of IP where you don't really need a registration to protect. The moment you create a work, you are believed to be the owner of copyright in the work. You are considered the owner of copyright in the work, as opposed to patents, as opposed to trademarks. Now, why is that? The difference between copyright as opposed to other forms of IP is that copyright law was created really to reward authors and artists. The idea of copyright law was that, individual authors and artists don't necessarily have a lot of commercial strength, and so they may not be able to go and secure protection in multiple countries, etc. It would cost a lot of money, but they should be protected, and therefore copyright is the only form of IP where you don't need to get a registration to claim protection. And as far as the term is concerned, now please appreciate the fact that this term varies from country to country. Quick little interesting anecdote. As far as our law is concerned, our law earlier used to be 40 years and then 50 years and then eventually became 60 years. And you know because of whom? It is because of Rabindranath Tagore. Because the works of Rabindranath Tagore were going to go into the public domain. And so there was a lot of lobbying to keep the copyright a little bit longer. And so the term was eventually extended up to 60 years from the death of the author. So today in India, you have Rabindranath Tagore to thank for the copyright protection, extending in copyrightable works to 60 years beyond the death of the author. And similarly, the person who the United States owes its thanks to is Walt Disney. So after Walt Disney passed away, similarly, there was lobbying, and what ended up happening is their law is called the Sonny Bono Act, because of which protection term also got extended because of Walt Disney. So as far as copyright protection is concerned, so literary, dramatic, musical, and artistic works, which are essentially works that, like I said, are created by individual authors and artists, the individuals that the law sought to protect, those have a term which is 60 years from the death of the author. Whereas things that we associate more with money or with greater commercial value, things that are not really created by individuals, like films, like sound recordings, photographs, they enjoy copyright for 60 years from the date of their publication. Also because, what happens with films and sound recordings is that it's not one person that owns the copyright. So in a sound recording, if you look at it, there is someone who's writing the lyrics, there's someone who's giving the music, someone else who's recording the whole thing. So the term starts from the time that particular song, for example, or sound recording was released. So it's 60 years from that particular period and not death of an author, as we understand the previous category. Now, if we move on to related rights, these are all rights that are covered under the Copyright Act. Performers' rights, the rights of actors, singers, musicians, all of these people to essentially put up their performance. Broadcaster rights, communication to the public in any form, whether it's the radio, whether it's, when we're talking about broadcast, we're not talking about telecast necessarily. We distinguish that in normal English as broadcast and telecast. But as far as the Copyright Act is concerned, essentially what we cover under broadcast rights also covers telecast. So whether it's communication through wireless diffusion, through sounds, or through visual images, all of that is covered under broadcast rights. There's also economic rights under the Copyright Act, basically to reproduce, to make copies, to sell, to distribute, display to the public, all of these. And like we talked about in patents as well, rights of assignment, licenses, all of these are covered under the Copyright Act. Now, moral rights. I had a young person called me up in a frenzy the other day. He said that he had written the dialogues for a film, and now the film was, the trailer was out, and he had not been acknowledged as the person who had written the dialogues. You often hear this, that someone wrote a story that someone else is using in a film, and that person is not, his name is missing. So he said, I got paid for it. Does that mean that my name, they get to remove my name from the credits? So the answer to that question is no. You may have got paid for the work, but these are some interesting things you must remember about our Copyright Act. In the Copyright Act, your copyright remains with you unless there is a written assignment by which you are giving the rights to somebody. So even if someone gives you money for it, unless there's a written assignment where you've given away your copyright, unless, of course, it's a situation where, they turn around and say that they commissioned you to do that particular work. So for example, a company commissions an ad agency to make an advertisement for them. That's a different kind of scenario because, you weren't normally making that ad. You made it only because someone paid you for it. That's different. But you've written a story. You've normally written that story. You've put it on a blog. You've put it on Facebook. And somebody says, here, take 10,000 rupees. I want to use the story in my next film. You can take that 10,000 rupees at that point in time. And effectively, it becomes a license to use that story in the film. But that does not mean that they get to delete your name as the person who wrote that story. And where you can claim that right from is called moral rights. So the moral rights, which owe their origin to French law. There is a concept in French law called droit moral, which essentially means that there are two types of moral rights. One is that you have the right of what is called paternity. Not really a good word to use in these times. I think we should make it gender neutral and therefore call it right of acknowledgement. And the second is the right to object against mutilation or distortion of the work. What does that mean? What it means is you have the right to be identified as the creator of the work, as the author of the work, as the father or mother of that work. And therefore you have the right to be identified as the creator. And the second is you have the right to object against mutilation of the work. There was a very, very famous case, one of the first cases in my career, which, it's a very rare case because you don't end up actually taking an issue with respect to mutilation or distortion of an artist's work to court. That kind of thing never goes to court. But we had this case where there was a very, very famous sculptor called Amarnath Sehgal, who had created these works that had gone up in Vigyan Bhavan and these murals, and he was internationally renowned, and he has made murals which are there in all over internationally at the United Nations, etc. So he had created this beautiful mural which was on the wall of Vigyan Bhavan, and that ended up, someone was renovating Vigyan Bhavan, and without knowing, they took the mural off the wall, and it ended up getting dumped in a storeroom somewhere. And then the building got painted and everyone forgot about the mural. And because it was made of metal, it ended up getting completely rusted and destroyed. So he ended up taking this issue to court, and the court ruled that, the fact that the mural had been distorted or destroyed meant that the artist's moral rights had been infringed. So even if you've been paid for the work, even if you have assigned your copyright in the work, you still retain your moral right. No one has the right to destroy your work. So what is copyright infringement? When somebody makes copies for sale or hire, now this is very important. All of you who secretly watch torrent films, this is the point where you need to sit up and listen to me carefully. Whenever somebody makes infringing copies for sale or hire, or distributes infringing copies, or imports infringing copies of a work into India, essentially, that is a scenario that amounts to infringement. In other words, if you're watching a torrent secretly at home, you're not necessarily going to go to jail. But if you're going to disseminate it and distribute it among your friends, you're in trouble. So watch out. So ultimately, what is important is that, jokes apart, you should not be using any unlawful means to copy someone else's work and distribute it or commercialize it, or even make it available in a non-commercial manner, because what you're ending up doing is infringing the rights of the copyright owner. And depending on whether the copyright owner wants to go to court and sue you, or they want to go to the police and file a criminal case against you, what you see on the slide will be the two remedies that are possible under the civil law and under the criminal law. So how do you get a copyright for music? That's a question that I've got. I've also been ticked off and told to talk slowly. I will. How can you get copyright for music? Well, like I said, I'm going to go to one slide later on in the presentation, so bear with me. Please stay awake until then, where I'm going to take you through the quick process of registration of each form of right, whether it's a patent, whether it's a copyright, whatever. But to simply answer your question right now, you would essentially, it would depend on, so again, music is not, music alone doesn't really tell me whether your question is about songs, or your question is about lyrics, or your question is about sound recording. So under copyright law, all three are separate copyrights, but whichever of the three it may be, you essentially apply to the Copyright Office with copies of it, and you identify yourself as the owner, as the author or the creator of that work, and then it's sort of inspected, and then the Copyright Office, if they find that it's fine and it doesn't it's not claimed by someone else, no third party has any rights over it, then they will give you a copyright registration certificate. It's as simple as that. Is copyright, now this is a whole bunch of questions that I've got, so I'm going to read all of them in sequence and then I'll attempt to answer them all together. Is copyright transferable? How does copyright play a role in a startup? Now, one of the most important things that we learn as lawyers is we need to be specific. If you want a specific answer to a specific question, you do need to ask me a very specific question. What role does copyright play in a startup? It's like saying, what role does science play in your lives? I can't answer that question. Why should I not download movies and music for free from torrent? I don't want to pay for them. Suggest ways to not commit piracy. Simple, don't commit it. Why should you not pay for it? Well, similarly, why should you complain if someone copies your invention? You come up with something incredible in the lab, you want protection for it, and then you turn around and find that that particular classmate of yours who you never got along with from the first year actually has ended up commercializing your invention in the market. You're not going to like that, are you? Ultimately, what is very important is to understand that if we are going to cultivate an atmosphere or a climate of copying or taking someone else's rights without acknowledgement, we will end up throttling invention. Would I want to innovate? Would I want to spend hours and hours of my time and give up my sleep sitting in the lab to create something if I knew that I was not going to get any benefit from that, if someone else was going to take it away? Certainly not. So ultimately, please understand that innovation and invention ends up getting incentivized when there is a protection regime, when there is a reward at the end of the day for the person who is innovating. What rights do I have if my copyright is violated? You've got the remedies up there. Those are your rights. Can I make something by getting inspired from copyrighted material? What is inspiration? Now let's look at the Taj Mahal. 5 people stand in front of the Taj Mahal and take photographs. Each of those 5 people will have their own individual element infused in that photograph. Someone will have someone else's head coming in, or someone will have a perfectly clear photograph, with the sunlight falling on one of the domes. So ultimately, it is your perspective, your eye, which comes into play when 5 people are photographing the same thing. That is why no 5 photographs will look exactly identical, right? So the inspiration is the Taj Mahal. You don't have to create something to photograph it, but all of those 5 people are going to have copyright over their own photographs. So the test really is whether you're actually substantially copying a work, or you are only seeking inspiration from it and coming up with something that is entirely original. That's the test really. And I think the next question is something I've already answered in the course of this. Yes, you can have copyright over photographs. Like I said, photographs also constitute artistic works. Right of research articles under copyright? Of course, any article. A literary work can be a research article, it can be a story, it can be fiction, it can be non-fiction. Everything is copyrightable. Ultimately, it is a literary work. And incidentally, the source code in computers is also a literary work. And therefore, everything that is a literary work. So for example, if you look at a website, the source code of a website, or the look and feel of the website, including the screenshots of what each page looks like, all of that is subject to copyright protection. So we would typically file CDs with the entire website, the photographs and screenshots and the source code, etc. So you could get copyright protection for all of these forms of work. Now we move on to trademarks. What is a trademark? Now, brands and trademarks are terms that we use interchangeably in everyday life. So a trademark, as you can see from all the examples from everyday life that are up there on the slide, a trademark is typically something that is capable of being represented graphically, and distinguishing the goods or services of one person from those of others. So it could be anything. I mean, traditionally, obviously, you do know that a word that is used for someone's business is a trademark, a logo that is used is a trademark, but equally, color combinations, numbers are trademarks. Now, let me ask you a simple question. When you see, of course, now, I mean, it's not my childhood anymore, so there's no point in talking about or my youth anymore, so there's no point in talking barista. I think Starbucks is the new barista. So if you see a Starbucks sign from a distance, you don't have to read the name Starbucks. You'll see the colors and you know it's a Starbucks. If you look at Google, so if you see those 5 dots or 4 dots on your screen, you immediately know it's Google. You don't even need to see the word Google, right? So today, you do have to understand that in the modern world, trademarks have gone beyond words. So for example, if you see what is called the swoosh, right, that is used by Nike, like a little tick mark, the moment you see that, you know that's Nike. So these are all trademarks that are visual or graphical images that don't use words. And these are also capable of being trademarks. What is a trademark? Therefore, summary, word, symbol, color combination, shape, numeral, packaging. What is not a trademark? Descriptive words. Like a cake for a cake. If you say, my trademark is cakes, and I want protection for cakes, and no one else hereafter can call a cake a cake. Obviously, you're not going to get protection for that, because that describes the product. So anything that describes a product cannot be a trademark. Trademark, but please understand this, and there's often a misconception that if a word is in the dictionary, that means it's a common word and therefore it's a descriptive word. No, it's not. Apple. Apple means fruit, right? So in the dictionary, when you see the word apple, it does not mean computers. So the use of a word like apple in relation to computers is not descriptive use of a word. So when you pick up a word that has no correlation with your product and you adopt that as a trademark, that is not descriptive. And therefore that is capable of being a trademark. National and religious symbols. Can you take the Ashok Chakra or can you take the Ashok Stambha and you say that, you know, these are my trademarks? Of course not. You can't take the national flag and say that is my trademark. So these are national and even regional symbols of states, etc., local symbols. None of those are capable of becoming individual trademarks. Why? Because a trademark is something where, like a patent, like I talked about, or like a copyright, you would get protection where the law would give you the right to call yourself the sole owner. So you cannot have a situation where you end up monopolizing solely a national or regional symbol or a single color. You can't say, I am Red FM and I own the color red. No one else can use red ever again. That's not possible. Or you can't take a functional or common shape and say, I own this particular shape and no one can use it. Or single numbers or single letters, or even a functional packaging. So anything that everyone else has a right to use, you can't claim to be your monopoly. These are what we call non-traditional trademarks. Sounds, packaging, scent, motion, shape. These are all non-traditional trademarks. So let's talk about shapes or packaging together. Now, I'm sure most of you are familiar with the Toblerone chocolates and how they come in those little mountain-shaped packaging. Now, that's really unique, right? Why do you think no one else makes chocolates with that packaging? The answer is simple, because Toblerone has a trademark registration for it, for that particular mountain-shaped packaging. So it is possible, without the word Toblerone, without the yellow and red color combination, to have protection just for that packaging. Scent can also be a trademark. So let me show you some examples. If you see here, you've got the shape of the Rubik's Cube. Now that particular shape and the way the Rubik's Cube functions, that is protectable. if you look at the packaging, right? If you've got Pepsi or Coke or whatever, the color combination without the use of words is also something that is capable of being a trademark. So in order to be able to register a trademark, you have to be able to represent the mark graphically. This means that for trademarks that are not words, you can use symbols in the form of text or drawings or a combination of both. In other words, what you can do is, when something is not a word trademark, like the packaging, for example, you can remove all the words from it and you can simply apply for registration of the color combination using the symbols. For a sound trademark, what you need to do, and this is a little interesting, you need to give an accurate description of the sound. So what is the melody like? Not everyone knows how to write musical notes, right? So you will have to describe it as well. What instruments are being used? What are the elements that make up the sound? And of course, if you can represent your sound using a musical notation, then for example, that is the easiest way to do so. So what do I mean when I say elements that make up a sound? Look at the description, the example I put up on the screen. A trademark contains a melody of two overlapping instruments, the piano and the sitar. So in other words, what I'm saying here is that these two melodies, or the fact that they overlap, may not be representable through musical notations. So that is a situation where you will have to use a description. Or you can use it, you can describe it using words. A trademark is made up of two dogs barking over the sound of people clapping. So that is not something that even constitutes melody. Forget using a musical notation. Let's look at my favorite example of sound trademark. I'm sure you watch films, and I'm sure you watched a film by MGM, and you know how with MGM motion pictures, the moment the film begins, and I don't know if I can play this. Do we have a means to play the sound file? No, we don't. That's unfortunate, but we do have a sound file here. But if you sort of look it up online, this, by the way, is a photograph from the actual shoot that took place. So there was a real lion who was brought into the studio, put in front of the camera. As you can see, the fellow's height has been raised in order to bring him face to face with the camera. And he roared, and his roar was captured. And that went into the famous MGM sound trademark, which we all have seen in the theaters. Of course, what we see now is an animated lion which raises its head and the roar comes out. But in the early days, if you see films from the 70s and 80s, you actually have this guy showing up on the screen, with waving his head and roaring. So that is a trademark. Can we play this? There you go. That was the sound file. That was the sound file that was submitted by MGM to the trademark office. So obviously this is not something you can show through a musical notation. You can only describe it as two short bursts of roaring by a large male lion. Now smell. Smell is again another interesting aspect of trademark registration. I do need to clarify that while you can get sound trademark registrations in India, you can't register smells in India yet, but some countries allow it. So this, for example, is an Australian example where the fragrance of the eucalyptus is a registered trademark in Australia, which is registered in favor of a company which is selling golf t-shirts, where the t-shirts are infused with that smell. So, there must be people who like that. Now we've got a question in between about whether a logo can be trademarked. I think I've given you examples of several logos in my previous slides. So the answer is obviously yes. How does a trademark help a startup? Again, what do I say? Trademarks, IP in every form. Whether you're a startup or whatever it is, it doesn't matter what size, doesn't matter when it comes to trademark law. ultimately, you need to be able to identify products as yours. So if I go to the market and I say, I want soap, then I'm giving the option to the person who's selling the soap to give me whatever brand he wants. Whereas if I go to the market and I say, I want soap of dash brand, then I've made a very specific request, right? So what is that dash brand? That is the trademark. So by using that particular, so what happens? Why am I asking for soap of that brand? Because I've used that brand, I like that brand, I believe that that soap is good for me, whatever qualities it has, whether it's soft, whether it resembles love, whether it, is good for my skin, whatever it may be, ultimately that particular soap brand appeals to me. So I want to go back and I want to use it again and again and again. So what am I getting? I'm getting, by creating a brand and by creating a good product under the brand, I'm getting customer loyalty. So this loyalty is good and important for whether you're a startup or a large corporation. The loyalty is what will ensure that customers will keep coming back to you. Therefore, ensuring that you have proper trademarks to identify your products will mean that you will create brand loyalty. And how can a shape be protected under trademark? Like I said, I will have a slide at the end where I will have a little bit on all forms of registration. So like I said, you draw the shape and you apply for it. That's how you're going to get the shape protected. You will make line drawings of the shape and you can apply. But please stand by for the registration slide. So what is counterfeiting? We've been talking about copying and counterfeiting at the beginning. And if you remember at the start itself, I said that the two prongs on which intellectual property law rests are the prongs of protection and enforcement. So what is enforcement? Enforcement is essentially the way by which you can prevent somebody from copying what you have. So the various means of doing that. So counterfeiting is the problem, and I'm going to talk about the solution. So first, let's understand the problem. What is a counterfeit? A counterfeit product is an exact copy of a genuine product with the same words and logos or colors that are so similar that the first time you look at it, you mistake it for the real product. Now, if you see the first photograph that I have up on the slide is Cantrol. While it says Cantrol, for all practical purposes, it looks like Castrol. It's copied the color combination, it's copied the way the word is written, it's got the dots below it. It's very, very similar. Burger King and King Burger, they've just flipped the two words, but for all practical purposes, it's the same thing. So these are examples of copying. These are examples that are called infringement in trademark law. And these are the kind of scenarios against which the owner of a brand can file an action, either a civil action in a court or a criminal action with the police. So let's play a bit of a game. So this is, it's me trying to play the game with imaginary people, because none of you are ever going to be able to sort of answer back on time, but we're going to play Can You Spot the Fake? If you look at these two products now, the International Trademark Association is an association of brand owners worldwide, and they have this campaign called the Unreal Campaign, which goes to schools and tries to encourage children not to buy fake products just because they are attracted by brands. So this is a great campaign which actually, explains the risks of using fake products to school children. So if you look at these shoes, for example, they look similar for all practical purposes. Many of us, including me, perhaps, if I look at this product in the market, I would not know which is the genuine product and which is the fake. Now, this is a shoe by the famous brand called Timberland, which makes these outdoor adventure type shoes. Now, let's look at so first of all, point to note, the first product was fake and the second product is the real one. So how do you know that? Now we start getting into the kind of domain that we as IP lawyers get into. In other words, we are getting into the domain of making distinctions in counterfeit products that are very minute. So the examples I showed you at the beginning, the Cantrol and the King Burger, anybody seeing that will say, oh, obviously Cantrol is fake or King Burger is fake. But this is not so easy to answer. So this is when you start going into things like, the laces are taped, whereas in the genuine product, the laces are burned at the end, right? Because there's a sealing. So then you see that the logo is not properly stamped in. The leather is not as good as the real product. Or the counterfeit product, the eyelets, those little circles through which your laces go in, those eyelets are not, they're not proper, they're just stamped in, right? So these are the kind of things that you need to start, because please understand that we may have great forms of IP that we want to protect, but ultimately each one of us here is a consumer first. We need to protect ourselves. We need to make sure that we're not buying fakes. We need to ensure, a study had been done by the Automobile Manufacturers Association, SIAM, along with the Automotive Component Manufacturers Association, ACMA. And they said that a very significant percentage of road accidents are caused because people take their cars for repair to small time, unauthorized repair places, and they end up putting either counterfeit oil, they put fake oil in your car, they put fake lubricants, they put fake grease, they put fake auto components, and a lot of that contributes to accidents. So never make the mistake of thinking that, oh, I can't be harmed by fakes. Like somebody asked me a little while ago saying, why can't I download and watch a film for free? Please understand that fakes are there in every aspect of our life. If we're eating a fake medicine, if we're consuming a fake medicine, we won't be cured of our illness. It could be poisonous to us. We could die. So we have to ensure that every time we promote something that is fake in one field, we must remember that it can come back and really hurt us in another space. So it's important that when we talk about fighting against fakes, that you understand how fakes can impact every aspect of our life and really stay away from fakes. Now here again, another example, luxury products, shoes, these are the most commonly copied. So if you look at this again, the two shoes look very different, but overall, as you can see, both are, obviously the fake has also been created to give off an impression that it is a Puma shoe. Now, what are the differences? The logo is too small. In the normal course, the logo is really big, and the logo is embroidered onto the shoe. So you actually see that it's a thread, and in this case, it's just stamped on. So now we move on to, but before I move on to industrial designs, I'm going to pause this here and take a couple of last questions on trademarks. So somebody says, a company A has a trademark registered in Korea. Can I register the same in India? Now, first of all, why should you be copying someone else's trademark and trying to register that in India? Let's leave the law aside on the morality of it. Why don't you create a trademark for yourself that will describe your brand rather than, look at possibilities of legal risks? So this is not a straightforward answer that I can give you. It will really depend on a lot on the facts. It will depend on whether that company from Korea has what we call legally as trans-border reputation in India, whether they have use of the mark in India, whether their products are being sold in India or not, whether they have presence in India. So, not as a lawyer, but as a person, my general advice to you would be, don't try and register someone else's trademark if you already know that it is someone else's trademark. Can the taste of biryani be trademarked? No. As you've seen in the slide where I talked about the types of things that could be trademarked, taste of biryani or taste of any form was not on that list. How to identify first copy in local markets? I think at the end of these slides, you will understand that there are these minute differences. So at the end of the day, as a trademark owner, one of the first things that any brand owner will tell you is that the price point is the first point of differentiation. If someone comes to you and tells you in the greater Kailash market that I have a Rolex watch that I'm giving you for really cheap, only 5,000 rupees, you really don't need to get into the minutiae of comparing whether, the numbers are proper or the trademark is written in the proper way. That price alone should be enough to tell you that it's a fake product. So if the product price is, and it often happens that you end up buying something on an e-commerce portal and then, what you get at home, looks suspiciously like a fake. Now the price is close to the price of the original, so that is not telling you whether it's a fake or not. That is when you start looking at these criteria. And at the end of the day, the best part is we live in 2019. Our greatest tool is the internet. Most of these companies, these brand owners, have a lot of information available online on their websites with respect to how to spot fakes. So if you try and educate yourself on how to spot fakes, you will find that there is so much information out there that you could actually use to your advantage. I think we're done with questions. So now I'm going to move on to industrial designs. Industrial designs are features of shape, configuration, pattern, ornament, colors, lines, etc., which are applied to an article. In other words, what is important to remember is that industrial design patents don't protect. So sometimes you make a product that's not a novel product in the sense that ultimately it's a chair. You've just made a chair, but it's a really different kind of chair. Chairs never looked like that before. So that kind of a product is where you get an industrial design registration. So if you look at the photographs, let's look at the fourth photograph, for example. Everyone can tell that it's a bulb. So you're going to turn around and say, how do I get protection for a bulb? Ultimately, what I've created is a bulb. It's an LED bulb. Everyone knows LED bulbs, right? But the shape of my bulb is really unique. So it has this little, figure of 8 kind of double shape. And no one has ever had LED bulbs in that shape before. So how do I protect that? That is what you will protect then through an industrial design. The design of a car. All of these products that the photographs I've got, where essentially this is a unique feature, pattern, or shape of an article, which again is applied by an industrial process, and which only has an aesthetic function. It does not have any functionality. The moment it has functionality, the moment it's giving you a particular result, is doing something that no one else did before, you go into the domain of patents. But if it is only to be judged by the eye, its only purpose is to look good, then that is something that you can protect through industrial design. So the moment it is functional, you don't get industrial design protection. It is registered by the design controller in the Indian IP office, and the term of a design is 15 years. So like a patent has a term of 20 years, a design has a term of 15 years. One thing that I forgot to tell you, trademark was copyright also, we talked about term. For a trademark, the protection is forever. Because you can't say that, the Tatas will no longer own the trademark Tata after 60 years. That's not possible, right? Because brands and companies outlive human beings. So the maximum term for protection otherwise is in copyrights, which is 60 years after the death of a creator. But more than that is trademarks, because trademarks outlive individuals. Trademarks are associated with companies. So no one can say that after a particular time period, someone builds up this huge brand and builds up this huge enterprise, and that brand or that enterprise will become mine. So trademarks have protection forever. Every 10 years, a renewal has to be filed. So if someone does not renew their trademark and it lapses, then that trademark becomes free to use. Industrial designs have a 15-year protection. Once that validity period is over, you can use that design like patents. Geographical indications. Now, some of you may have heard about geographical indications, the turmeric, well, not the biryani exactly, but, a lot of food products. Recently, you must have read about how there were our members of parliament were hotly debating Orissa rasgullas and West Bengal rasgullas in parliament. So these are all geographical indications. What is a geographical indication? Basically, a geographical indication, or a GI as it's called, it is, like you may have seen the craft mark or the wool mark or the silk mark on products. So a GI mark is something that is used on products that have a geographical origin, and they possess qualities or reputation which are due to that origin. Now, essentially what I'm saying here is that when you talk about a product as coming from a particular place, now you've got examples here on the screen of Darjeeling tea. a particular form of cheese. You've got the Madhubani painting from Madhya Pradesh, and you've got a Phulkari dupatta in the fourth photographs. Now, all of these, the moment you say Madhubani, a person knows that I'm talking about Bihar. Someone says Darjeeling tea, you know I'm talking about West Bengal. I say Phulkari, you know that comes from Punjab. How do you know that? What is there to say that Phulkari does not come from Tamil Nadu? You're going to laugh at me if I say Phulkari from Tamil Nadu, right? Because you know that that is something that is specific to that region. It's an embroidery style that people in that region make. So a geographical indication is something where when something is made in a particular region, in a particular geography, and the quality or the reputation is because it comes from that place, then you get a protection called a geographical indication. Now, the main difference between something that is a geographical indication versus other forms of trademarks or other forms of IP is that it is not given to individuals. It's given to the society, it's given to the representatives of that particular area, whether it's a trust or a society that is formed by the weavers of a particular area, or maybe, maybe the tea growers of Darjeeling or Assam of a particular region come together and they form a society. So you have to apply as a collective, as a group of people, you apply for a geographical indication. You have to demonstrate that an agricultural, natural, or manufactured product from a particular geographical territory, so that's what you can apply for. And what you're essentially doing is, see, like, let me give you an example. Come winter, at least I can speak for Delhi. Every time you go anywhere in the market, people tell you, "Didi, pashmina le lo," or, this is pashmina. And everybody knows that that's the most abused word ever. None of those are pashmina, right? So how do you know? Like somebody said earlier, how do I know if a particular product is a fake? Exactly. How do I know if a particular product, a particular shawl is actually pashmina? How do I know if this is actually Darjeeling tea? The only way I will know it is if it has a geographical indication, which means that the government has tested and checked and confirmed that this particular product made by this particular group of people from this region is an authentic and genuine product from that region. So therefore, the importance of the geographical indication. And obviously, it's very important for the people who come from that region because it gives them a certain assurance that their products will not be lost in the market among fakes. The registration is valid for 10 years. And again, like trademarks, it can be renewed forever every 10 years. Now, somebody asks, where can I buy products bearing geographical indications from? You know the interesting thing? I was quite amazed to find that even local weavers, local manufacturers are all aware of GIs. So when somebody says that this is a genuine example of so-and-so, you just need to turn around and say, do you have a geographical indication for it? Can you show me? So something that has a geographical indication will typically bear the GI stamp on it. So like I said, like the silk products which bear silk mark or wool mark or craft mark, like that, you will have a GI label on it. Although it's not a guarantee, but typically in the government, in the state showrooms, you would find geographical indications indicated prominently on products. If someone is a weaver, you're going to an exhibition, look for geographical indications. But having said that, of course, not everyone has got organized. I was going through the geographical indications registry the other day, and I was amazed to find that Karnataka has the highest number of geographical indications. It's amazing how many things have been registered from there. So it, it covers things like food. It covers, from things like Mysore Pak, or somewhere in the Tirupati Laddu, for example, also has a geographical indication because it only comes from the Tirupati temple. Similarly, the Kawa tea in Kashmir, or Assam tea, for example, or the black rice in the Northeast. These are all geographical indications. So right from the food you eat to the clothes you wear, different things are covered by geographical indications. Now, the purpose of a geographical indication is that the reason why it is called a geographical indication and not a trademark is because there is a certain thing, quality or attribute associated with the product which comes from that geography. In other words, essentially what you've got is black rice, which is called black rice, or it looks black in color because it grows in a particular region which has a particular soil type and particular climatic conditions. That is why the rice turns out that way, or that is why you get rice. Or it's a particular skill set that a group of people in that region have. So like the Rasgulla example. So that is the reason why, to answer the question that I just got with respect to why GI is not an individual right. Geographical indication is not something that you've created as an individual. You can't say that I alone should be permitted to monopolize the benefits that being in a particular place I have got. So for example, somebody is a weaver who's weaving Banarasi saris. Can the weaver say, I alone should be allowed to weave Banarasi saris? Clearly not. Everyone who works in the weaving cluster in Banaras, all the weavers have equal rights to call their saris Banarasi. And therefore, that entire cluster will get a geographical indication registration and not an individual. That would not be fair. Moving on to semiconductor integrated layout design, perhaps the most unused of all forms of IP. This is essentially, a product, a semiconductor integrated circuit is a product which has transistors, it has circuitry elements, essentially an electronic circuit that is an innovative circuit that you have created, a circuit layout design, which has transistors and other elements, and including lead wires. And that is something that you could get a registration for that particular circuit layout design. The last that I had looked, I think only perhaps ISRO and BHEL were the only two people who had semiconductor integrated layout design registrations. No one else did. So this is not a particularly used statute. But in order to get registration, that is essentially, again, similar to trademarks, similar to designs, in the sense that you would get a protection only for a period of 10 years, and after that it goes into the public domain. This too should be original. It has to be distinctive. It has to be different from any other layout design, and it should not have been commercially exploited anywhere in India or in any other country which follows the Semiconductor Convention. Plant variety protection. I'm sorry, I do need to rush through these a bit. We've taken quite a few questions, but these are kind of, we do have, unfortunately, it's like, as a parent, I can't choose a favorite child, but it is true that some of the children are not really, that important as the other children. So these, as far as semiconductors, etc. are concerned, these statutes haven't assumed that great importance in the Indian context yet for me to talk about it at length. As far as plant varieties are concerned, Plant Varieties Act is essentially a law that recognizes plant breeders and farmers who are focused or who are contributing in developing, improving, and cultivating new varieties of plants. So those of you who are in agricultural institutes who are listening into today's program, this is a statute that you have to pay very close attention to, because this is something where, and I'm just going to take you through the steps. So essentially, this is a Plant Varieties and Farmers' Rights Act that gives IPRs to farmers and plant breeders who are able to cultivate or develop new or extant plant varieties. In other words, either a new plant variety or a plant variety which is still alive. It recognizes the farmer as the cultivator, the conserver, and the breeder. So when we talk about what is still alive, what the statute says is that if it's an Indian plant variety, then it should be existing for at least 1 year. So in other words, it should have gone through one full life cycle and it should have regrown again, because it can't be that you come up with something and at the end of one life cycle, you're unable to replicate it. And it's sort of that particular strain dies out. So if that happens, then you can't get a protection for it. So if it's gone through a life cycle, you've come to a second life cycle, then you know that that is living still. That is what you could get protection for. And if it's something that you basically created overseas, then you get a time period of up to 6 years. You can register it in India if it's a plant variety that has been created outside India. So criteria for registration is not that different. It has to be novel. So again, like patents, like designs, this too has to be novel. You can't just go and register an existing plant variety. It has to be very distinct. It has to have either a distinctive trait or a distinctive quality which sets it apart from other plants in that particular family. It also has to be uniform. In other words, every cycle that it is grown, you should get the same result. The strains, except for the biological variations that happen, the strains should more or less be uniform and stable. Only then you can get registration as a plant variety. Trade secrets. This is a really fun area, something that curiously I've been working off late a lot in, and that primarily is happening because a lot of companies find that, they don't want to get patent protection, they don't want to give away trade secrets. One of the most famous cases of trade secrets is the Coca-Cola formula. So that was not patented because they said, you know what, we see our product as something that will live beyond 20 years. We don't want it to go into the public domain. So no one ever knows what is the original formula of Coca-Cola. So a lot of times what ends up happening is that, people choose to keep their knowledge, to keep what they've invented as a trade secret. They keep it very close to themselves. They keep it confidential. And they reveal it to people only on a need-to-know basis. And they don't disclose it. They don't patent it. They don't secure protection. So trade secrets is exactly the opposite of everything I've talked about so far. Everything else that I talked about so far involves you revealing what you created and getting protection after you've revealed it. Trade secrets is, you know it, you keep it to yourself, don't reveal it to anyone, don't get registration, don't get protection. It remains, as that photograph suggests on my slide, top secret. So how do you protect something that's a secret? It could be R&D information, something as simple as a company may say my customer information list is a trade secret because, the prices that I give my customers is a trade secret. I may have a particular formula which I use. I may have consumer profiles, advertising strategies. I may have certain policies. The reason why I'm so successful as a company, because I have a lot of interesting data and I'm mining that data very carefully to my commercial advantage. And I don't want to disclose any of that. So that is a trade secret. So then how do you protect a trade secret? Like many countries, India does not have a statute to protect trade secrets. So trade secrets are protected through common law and equity. What does that mean? In other words, when a business, so suppose you join a company as its CEO. So obviously, you will need to know the trade secrets of that company because you have to run that business once you become its CEO. How does the company secure itself? The contract that you sign with the company in your capacity as CEO, that contract will say that you will never reveal that trade secret until you die. It doesn't matter whether you're with the company or you've left the company. So the way trade secrets are protected is through confidentiality agreements for employees and vendors. And you make sure that nobody discloses that information. It can be protected for an unlimited period. And what happens is, if someone discloses that information, then you essentially take them to court. Do remember one very important part about trade secrets protection, and that is when you are protecting a trade secret, what you are essentially doing is you are deciding the means by which that information is to be shared, who it's to be shared with. You have a lot more leeway, unlike the others where the law tells you what to do. With trade secrets, you decide that 5 people will know or 10 people will know. So someone may say, look, I wasn't trying to take benefit of it. I just told my mother or I told my sister. That's not the point. You decide Who will know? So all that information is shared only on a need to know basis. So let's look at common everyday application. You come up with a very interesting idea. You want to create a particular software. Now you have the whole idea in place, but you want a company to develop an app for you. So you engage a company, that company develops the app, and they take that whole idea and they give it to somebody else. So that is the kind of scenario where you must make sure that when you've got an external software developer or an app developer, someone else doing that job for you, doing a part of your work for you, that you have these contracts in place which have confidentiality clauses, which say that that company is not going to give away your trade secret or your confidential information. Ultimately, so this is the recap slide that I was talking about, where we're looking at how different forms of IP can be protected to answer all the questions that came in about types of protection. So for trademarks, you file an application for registration. That is the ipindia.nic.in is the website of the IP office. You can choose to file directly, or you can choose to file through a lawyer. But you file your application, you go online, and they've got very user-friendly segments, portals. They've got frequently asked questions to tell you about that particular. So they've got different tabs for trademarks, copyrights, patents, and you can go to each of those tabs, learn more about it, click on the relevant tabs, and you can apply for it. You have to mention your name, your address, your goods and services for trademarks. As far as copyrights is concerned, you will remember I told you that copyrights aren't, registration is not necessary, but it is a good proof of title, because hey, how is anyone going to know that you clicked that photograph of the Taj Mahal? If you've gone and got a copyright registration for it, that's the best way that you can assert that you are the owner of that photograph. For patents as well, if you remember, like I said, rights are available only upon registration. So again, you go to the IP India website and you get a registration. Designs, again, same thing, no unregistered right, neither for plant varieties. I've told you this. These are all basically on the IP India website. Once you go there, you'll be able to click on each of the tabs. The Plant Varieties Authority, the Plant Authority, is a separate standalone authority that has been constituted by the government. So you go to plantauthority.gov.in to file your application for registration. And like I said, trade secrets, no registration, you protect it through confidentiality agreements. Finally, geographical indications. Once again, you go back to the IP India website and remember what I said in response to your question: no individual applications, associations of persons or producers or any organization or any authority can apply. And of course, semiconductors, again, individuals or associations can apply. That's the SICLDR.gov.in is the website that you must go to for semiconductors. Finally, as individuals, each of us have a responsibility towards IP protection. So responding to that gentleman who asked about why you shouldn't download torrents or why you shouldn't copy, remember, the more original we are in our business approach, the more likely we are to be able to create something that is lasting. Something where all of us, every one of us, it's almost like a human quest for immortality. All of us would like to be known for what we leave behind, for what we create. So focus on innovation, focus on creation, be original. Don't purchase and access counterfeit products and pirated content. It will come back to bite you in some way. Like I said, you may think there's no harm in buying a luxury handbag or a shoe, but think about a pirated medicine. Think about a pirated auto component. Don't encourage piracy. You should do your due diligence. Don't register that trademark of another Korean company. Create your own trademark. Create something that everyone identifies as being associated with you. And ultimately, focus on securing protection for your own IP. Like I said, protection and enforcement are the two pillars of IP. So if you don't protect your own IP, if you don't go through the steps, if you say, I'm going to be lazy, I'm going to sit back, I'll create these inventions and expect that no one copies them, that's not going to happen. The only way others will know that it is your invention is if you take the active steps to protect your own IP. Only then can you prevent someone from copying it. And finally, it's important to remember that there is a lot of fillip that is being given by the government towards entrepreneurship, towards, we got a lot of questions on startups. So it's important to understand that as a startup, if you want intellectual property protection, then there is a great scheme that exists, which will essentially offer a reduced fee for trademark and patent filing for startups. There are people who are empaneled as facilitators, individual IP lawyers who are empaneled as facilitators with the government, and they will be able to, obviously within limits, but they will be able to assist you to a great extent in terms of being able to apply for registration of your patents or your trademarks. So the government will essentially, you will be able to pick somebody from the list of approved facilitators, and they will essentially be applying for registration of your IP on your behalf, and the government will be paying them the fee. You won't be required as a startup. If you're empaneled, you will not be required to pay any fee at all. So that's something that for some time period, this scheme has been launched, where the government is essentially subsidizing the cost to encourage innovation. And there is a manual that is again available on the IP India NIC website on the IP facilitation for startups. You can look at that manual, and there are lots of other information that is available. For startups, there's also an expedited process of registration, basically to incentivize innovation and creativity. Thank you very much for being a not so silent audience, despite the interesting interface of the medium. Thank you very much.
You should sit. I think you would have certainly had some interesting learnings from this session. I'm really thankful to Mujumdar Madam for coming all the way here. What I have realized when I was watching some of the things from outside is that the light here is pretty low, and we need to actually ensure that next time we might do this in studio or something, so that the delivery is far better from an experience perspective. I think I was going through some of the things which Madam was covering. The examples she was giving, it's really good. And I think, Madam, you should have shared your website or contact details with some of them, or not directly your number, but so that if they have any queries, then they might reach out to your or DIPP's, anything, because the primary objective behind this entire initiative is to create local islands of innovation within our country.
Certainly.
So we are trying to actually create 1,000 such islands and their own ecosystems, but institutions, especially in the remote areas. There are no experts who can help them or guide them beyond a particular, what we can say, stage. Okay. So we are trying to explore whether we can create a combination where some initial basic help can be given by local experts, and when it moves beyond that stage, we actually come back to people like you who are experts and who can actually help them take it to the next level.
Certainly. I think I'll very quickly respond to that, sir, and say that the idea of today's exercise was to keep it authentically academic and therefore not to promote myself or my firm, which is the reason why in respect of that authenticity, we didn't put it out. But having said that, like I said at the beginning, the best part is we live in 2019. Anybody who wants to find me can find me. There's always Google power.
So apart from that, as a DIPP, we can, because we are doing this in collaboration with DIPP. So we can share with you eventually all the information on email. If you can give us, ma'am, whether you will allow this PowerPoint presentation to share. If
absolutely.
That also presentation which could be useful for some of the students
Certainly.
as repository, or they can go back. Apart from that, this video will be there on Facebook, certainly. So they can go back to that video also whenever they require.
And
So-
don't forget the moral right of attribution.
Yes. Yeah, completely agree with her on this part. So I would like to take this opportunity to thank you from Ministry of Mhrd for sparing your time. I think we had about 600 colleges, 700 colleges live. And even if we say that there were 100 students sitting on that is a bare minimum which we are talking, because we had given them a target of at least 50%. So I think this must have been watched by not less than 50,000 to 1 lakh students. So this is the reach which we are talking about. I will give you proof in some time, because now these colleges have to upload the photographs of the actual what they did, and we have a platform, so they will soon upload the photographs also.
That should be fun.
Yeah, so we will share with you. So similar sessions we will be doing. As I said, we will use a better setup next time. We are also learning, so please bear with us. Maybe we have learned from day before yesterday's session with Anand Mahindra, and from this session, that we need to be far, far better, and we will work in that direction. So thank you for joining once again, and we are really thankful to you. Thank you very much.
Thank you.
Yeah? So we will take this opportunity to felicitate you, ma'am.
Thank you so much.
From Ministry of Mhrd.
Thank you.
Yeah, thanks.